Good morning again, and welcome to all participants in this Radcliffe Chambers webinar on the subject of professional negligence in the areas of wills and probate. My name is Katherine McQuail, and my colleague Marcus Flavin is presenting this webinar with me today.
Hi everyone.
We're both members of Radcliffe Chambers and have been since Chambers was formed in 2006, and we've both spent our careers at the Chancery Bar specialising in wills, trusts, probate, private client and professional negligence claims arising from those areas. There is a Q&A facility in the usual way. I believe that only Marcus and I will see any questions that are posted, so please do post questions, and if there is time towards the end of the webinar, we will do our best to answer the questions that you have put in that facility. We have also prepared a list of key cases relevant to this area, and we propose to circulate that following the webinar to those who've attended or expressed interest in seeing a recording of the webinar on Radcliffe Chambers website. So what we're going to be doing this morning is talking through the process of a professional person taking instructions from a layperson for the making of a will and the carrying those instructions into effect. The idea is to identify and thereby avoid the sorts of errors that may lead to professional negligence claims in this area, but also to enable us all to identify where and when and why a claim may lie when what is usually an intended but disappointed beneficiary seeks to complain about the way in which a will has treated them. The premise is that any will instructions would be taken over the course of a number of meetings or telephone calls or virtual meetings, but we would suggest that it is almost always best practice to ensure that there is at least one face-to-face, even if virtual, meeting between the will drafter and the intending testator, and that at an early stage a request is made of the intending testator to produce to the will drafter previous wills that the testator, or any previous wills that the testator has made. So to start, I'm going to ask Marcus to explain what needs to be done before one even embarks on the process of taking specific instructions for the client's will. Marcus.
Well, obviously you have the KYC requirements and so on, but more crucially to what we're really talking about today, two important things you have to ask yourself about are, do you have the slightest reason to think that there may be want of capacity, or is there anything to suggest that undue influence may be in play? And whatever your conclusions on that, make a good file note. That may well be crucial to protecting both the will and yourself later on. If you're worried about undue influence, then you simply have to take a view and take what steps you can to minimize the risk and make a note about it. If you're all at all worried about capacity, Lord Templeman's golden rule, or as my pupil master used to call it, the golden if tactless rule, is still a good rule of practice. Get a medical practitioner to assess the testator and get them to witness the will and make a record of their examination. It's not a rule of law, and one notes the irony that we recently learned it wasn't properly observed when Lord Templeman's own will was drawn up. But if you do have concerns and you don't address them by seeking a medical assessment, you may well come in for criticism, even if you aren't found to be negligent, if the will is eventually held invalid for want of capacity. Now, there are cases, one good Court of Appeal case, where the court has been prepared to take the evidence of an experienced probate solicitor on capacity. They said, I think he was fine. over that of an expert who didn't see the testator and was simply working from medical records. But if you can protect yourself, why not do so? Urgency, of course, can militate against this. But if you can do it, think about it. On a rather different note, as ever, be clear exactly what it is you're being asked to do. What is the scope of your retainer? Your duties to the testator and your complementary duties to the intended beneficiaries is the starting place for looking at scope of duty is the scope of your retainer. In particular, are you advising on the tax position? Because the default is that if you do not say you are not advising on tax, you will be taken to be doing so. Now, a point I made earlier, and we're going to be making again and again through all of this, is the importance of keeping good file notes. A detailed attendance note can be your salvation if a professional negligence claim is eventually made against you, because that is your contemporaneous documentary evidence, which any claimant is going to have to convince the court to ignore. So you've done all of that, you've got the testator settled, and you're about to start the process of taking instructions. So Kath, tell us about identifying the beneficiaries or possible beneficiaries. What's your role there?
Well, clearly your role in terms of determining who the testator might be going to benefit under their will, it comes basically from the testator's instructions, and you may have a previous relationship with the testator, have done business with for them for many years, or there may be somebody who's completely new to you, and obviously the process of taking instructions must be tailored to fit that relationship. But there are a number of obvious questions which it would be sensible to get the answer to, and it would be also sensible not to assume from prior knowledge that you know the answers to those questions. Many testators have unusual lives, and the unusual lives sometimes have consequences. So the testator may not tell you the answer to all the questions, but if you've asked the questions and recorded the answers in your detailed file note, it's likely, again, as Marcus has said, that file note will protect you later. The first obvious question, and this possibly relates to the undue influence question, is who are the people who've accompanied you to the office today? Are they your cleaner who's decided that they'd like to have a substantial benefit under your will and has brought you along to have a will drafted, or is it your husband or wife? Establish that by the relevant and sensible questions, because the accompanying person may have a conflicting interest or be, as I've said, but possibly an potential undue influencer. You want to ask the testator who they live with, who they're married to, that's different, who they might be intending to get married to, because that obviously has a potential effect on the validity of a will you make. You want to ask who are their close relatives, their children, their grandchildren, anyone else who's sufficiently close that they might benefit them. You want to ask if the intending testator is presently or has recently been providing financial support to anybody, either within the above list of people that you've already established or outside that list. You want to check whether the testator has in any shape or form promised any part of his estate to anybody, because it's important to establish as a totality those people who a mentally competent testator might expect to provide for, those who are deserving of the testator's bounty, in the words of Banks and Goodfellow. But you also want to establish whether there are possible 1975 Act claimants or claimants by way of estoppel lurking out there. Obviously, the testator isn't obliged to make particular provision for those people or satisfy their prospective claims, but the testator should certainly be warned of the implications if they were not to, by the provisions of the will, satisfy those claims. Those implications both for the estate as a whole, for the disposition of specific properties, if there's a proprietary estoppel claim to a particular property in the estate. So the claims on the estate is one possible problem to warn of. And there's also the effect that a costs order in any such claim might ultimately have in depleting the residuary estate. So find out who all those people are and give the testator appropriate warnings about what might happen if people with obvious claims aren't going to be benefited under the will. So I've mentioned something about property and specific assets that the testator has, but Marcus, perhaps you could discuss in more detail the question of the testator's property and how it's held.
Yes, my view is that the best way is to go through the exercise of making them list out exactly what property they own. Ask them probing questions and check. In particular, when we're talking about land, which is usually going to be the main point, is it co-owned? If so, joint or several, and is it worth changing that? Is there maybe a latent beneficial interest claim, or as Kath already mentioned, a proprietary estoppel claim? And if there is, can you maybe sort that out now? Do they actually only have a life interest under a trust? And if so, what are the tax consequences going to be when that ends on death? Do they have any particularly valuable chattels? What about powers they may have, in particular, a general power of appointment exercisable by will? Have they got agricultural property or property attracting BPR? What about shares in partnerships or private companies? Do they actually have freedom to dispose of them by will? And if they don't, how is it supposed to work and what can you do about it? Of course, you need to think about the transferable nil rate band and also the convoluted mess that is the residential nil rate band. But is it going to be worth thinking about a 2-year IPD for a surviving spouse in property that may be going elsewhere ultimately? Are there any disabled beneficiaries who would be helped by a disabled person's trust? But conversely, if the client has come in and said, oh, I want a full-scale discretionary trust for everybody, because I've read about those, do they actually have a sufficiently large estate to justify the costs and the tax of running that? Do they really know what would be entailed? And then finally, do they have any foreign property? And if so, where? Is it somewhere there's going to be forced heirship? Wherever it is it something you feel comfortable dealing with it on your own and in this will? Or more likely, is the best answer going to be to try and find some lawyer overseas who will be able to cover that aspect of it? Kath, you mentioned earlier wills at the start. What do you think a solicitor ought to do about investigating those earlier wills?
Well, I think where we've got to now is a point in the process where you as the will drafter would be able to understand and assess the client's prospective will instructions, whether they brought them along on a piece of paper or whether they've now formulated them for you in the course of your face-to-face meeting. But as I said at the beginning, it is important to ask the testator to produce previous wills, certainly relatively recent previous wills, but there are, as I expect many people have encountered, there are some testators who seem to make wills every every year or two, and there may be a need to go back over a lengthy history to discover what's gone on in the past and why now might be different. So with an understanding of what the testator now intends to do, it is worth then looking at previous wills and asking for the testator to explain to you what the differences are and why those differences have arisen. Are they the product of a change of mind? Are they the product of a particular change of circumstance of a beneficiary, or the circumstances of the testator and the assets in his or her estate? If the testator can explain rationally what the changes are, obviously that goes in the file notes. If the testator can't explain rationally, that may be a cause for concern and lead to the need for further investigation. But dramatic, as I expect everybody is experienced in dramatic changes in will terms are often the cause of beneficiaries who suddenly don't benefit in the last will being deeply suspicious about what has gone on. So that if that is the case, it needs to be carefully documented. Another point is to be aware of the terms of any previous will which has the appearance of being a mutual will between husband and wife, usually. And if there is such a mutual will, it may mean that the testator who's now wanting to make a will in favour of perhaps a second spouse is actually contractually bound not to alter the provisions of that previous will, or holds property because of the terms of those earlier mutual wills, holds property which is subject to trust obligations. So again, it's something to be aware of. And while on that point, if a testator says to you they want to make a mutual will, or two testators come along and say they want to make a mutual will to husband and wife, think very carefully and explain very carefully what that would entail. In my experience, it is almost never a good idea to create mutual wills. So we've got some instructions. We've decided it's all rational, it's all sensible. We know it's all above board capacity and so on. How long have you got to get this will in place, Marcus?
It really depends very much on the particular circumstances. In a case called Hooper and Finmore's, a mere 12 days from taking instructions was too long and the solicitor was held liable. But there are many cases where longer delays haven't been held to lead to liability. Depends on facts as you know them or ought to know them. Now, if you have a terminally ill client, then obviously speed is important. It may, in some circumstances, even be worth considering a short interim will. Perhaps you could do it there and then, which at least achieves the broad brushes of what the client wants. Or perhaps you could put in a discretionary trust and a note of the general wishes. All this with the intention that, if possible, a fuller will is going to follow later on. The reality is there's a trade-off between speed and the chances of getting it perfectly right first time. So you do have to make a judgment call about that. If no will is ever executed in accordance with the instructions you were given, and the delay is your fault, for instance, because you failed to progress the drafting, then time for the disappointed beneficiary claim starts to run on the day instructions are given. And it's an important difference from the position with defective wills, which we'll come to later on. So the limitation position may be a bit better for you. General rule is get on with it, but don't rush it and make a mess of it unless, or run the risk of making a mess of it, unless the situation is so obviously urgent that you're in the Hooper and Fine wards, 12 days was too long to do it kind of situation. So we're going to skip mostly over the actual exercise of drafting the will. I'll just mention there's nothing whatsoever wrong with using precedents, but you do, of course, need to properly tailor them to your client. If you cut and shunt from a couple of precedents, so borrow a clause from one to drop into another, things can very easily go wrong, in particular definitions clauses, I think. So check, check, and check again. Make sure the remainder clause works properly. A problem I've seen more than once in the last 2 years is shares of residue that don't add up to 100%. Not sure whether it's worse if they add up to 103 or 96. Ideally, get somebody else in your office to read it through for sense. Resist the temptation to over-engineer, I think, and incorporate lots of provisions that aren't really necessary or helpful. I'm quite a fan of the step standard administrative provisions, but if you use them, check whether you want to include all of them. In particular, I think the special provisions are usually inappropriate. And I take the view you should actually download the step provisions, print them out, send them out with the drafts and the engrossments, and then later on keep a copy with the will.
Right. So we've drafted this will. It's got all the precedent clauses in the right order and matching up. How about execution, Marcus?
Well, obviously the ideal is to supervise execution yourself with another colleague to witness. Do it in your office and immediately make a full file note setting out what happened. But that may not be what the client wants, or it may be very difficult for them. The duty, according to Gray and Richards Butler, is to advise clearly and comprehensively on the procedure to be followed. Beg your pardon. To advise clearly and comprehensively on the procedure to be followed, and not necessarily to supervise execution in every single case. Though in some particular instances that may be appropriate. There's certainly at least one case where it was held the will drafter had a duty to supervise execution. So if you can't get it done in your office and you're not attending on the client yourself, you need to have very clear standard instructions on how exactly you are supposed to carry out execution. If that's going to be complicated by language, sight, or hearing issues, or the will is going to be need to be signed by some other person in the presence of the testator and at their direction, it's going to be even more complicated than usual. And if at all possible, I would advise trying to attend on the client yourself. In those circumstances, I might be inclined to advise not just making a file note, but actually making an affidavit immediately, setting out what happened and keeping it with the will. And in those cases, you also need to make sure that the attestation clause is right for what is going to happen. Compliance with section 9 is strict. If it's wrong, then it's an invalid will. It's your responsibility to check the executed will when it comes back to you, assuming it does. And if something's clearly wrong, for instance, it's not signed by everyone who should, then you are liable if you don't take steps to remedy. But if you're told everything was done in accordance with the instructions and there's nothing to clearly indicate that's not true, then you should be okay. Just keep meticulous file notes. There's no duty to chase a client who doesn't get back to you at all once you've sent them something. No absolute duty, it depends on the client. As the Court of Appeal said in Atkins and Dunn & Baker, clients do change their minds, and if the ball is clearly left in their court, it's up to them what they do with it. Sometimes, though, there can be a duty to chase. An example in that case was where instructions were to have a will executed before budget day. I'm not entirely sure why that should have mattered, since the will speaks from death, but that was the example the court gave. So we've got execution. What's your role as solicitor after that, Kath? Are you going to get the will back, and what are you supposed to do with it if you do?
Well, again, it's a matter in a sense for the testator to decide whether they want you to look after the will or whether they want to look after it themselves. But you might want to warn them that it would probably be safer if the will was in your custody, or if they were to register the will with the National Wills Register certainty, in order that there is then a certificate of registration of the will. I imagine that most of the participants in this webinar have in place a system within their firm for the storage of wills, and it's probably not for me to advise exactly how everybody should store their wills, but it must be the case that any storage system should be secure, fireproof, safe, that sort of thing. And it also must be the case that any sensible will storage system is going to have ease of retrieval of the will when it's needed as a feature of it. Otherwise, if you store it but you can't find it, it's not much use to anybody. You should obviously send a copy of the executed will to the testator, unless they specifically say not to do that. That sometimes happens. And you shouldn't send copies of the will to anybody else unless the testator specifically requests you to do so. So you need to be able, when somebody comes along and says, have you got Mr. X's will, to be able to put your hands on it sharpish. When you do store the will, it's important, in my view, that any original earlier will is marked as having been revoked by the new will dated whatever the date is. The possibility of the previous will coming out of the will storage system and being thought to be the last will is one that I've certainly seen happen. So the storage system needs to have, as a feature of it, the ability to know which will is the last will, which has been revoked for obvious reasons. So we're now, I think, moving on to the question of the event against which the testator was making his will, namely his or her death. So what happens, Marcus, if after the death of the testator it becomes apparent that a beneficiary or a non-beneficiary, a beneficiary who thought they were going to benefit but hasn't, has a doubt about the will that you prepared?
Well, if you have a valid but defective will, or possibly defective will, you may be able to construe your way out of the problem by a construction summons, or even permission to rely on counsel's opinion under Section 48 of the Administration of Justice Act. That possibility is often overlooked, I think. And alongside the construction summons, there can and probably will also be a rectification claim, maybe brought by you, but more likely it's going to be brought by one of the beneficiaries or disappointed beneficiaries. Rectification, we now know, can extend quite far. In Marley and Rawlings, the Supreme Court were even prepared to go as far as rectifying what looked to many of us at the time, including all four judges below, like defective execution, which shouldn't be capable of being rectified. The reality is, if the need for a construction summons or a rectification claim is your responsibility, which very often it will be if you drafted it, that one way or another, you or your insurer are going to be bearing all of the costs of the exercise. It's common to give other necessary parties to the rectification construction claim an indemnity for their costs and not to seek an order for your own. And even if you don't do that, you may be faced with an appropriate costs order at the end, making you pay for everything, as in fact happened in Marley and Rawlings. We come back again to file notes. These can be absolutely crucial for rectification because the whole jurisdiction is based on finding that the will doesn't reflect the testator's intentions, which means you need to establish what the testator's intentions actually were. And they can also be really quite important for a construction summons if extrinsic evidence is admissible in the circumstances of that will. But rectification and construction can only go so far, and they can't, Marley and Rawlings aside, say an invalid will. So what are you going to do if those claims haven't saved the situation? Kath?
Well, you may be stuck with advising the beneficiary who's approached you about your dodgy will, let's put it like that, to take other advice about seeking assistance in relation to the bringing of a probate claim to challenge the last will that you've drafted on the basis that there was lack of capacity, undue influence, or any of those matters. Or you may have the beneficiary who says, hang on a minute, there's only one witness on this will, so it's invalid, but you should have, and that may also be a problem. There won't be a probate claim in that situation, but there may follow a negligence claim when the estate is distributed to the beneficiaries under the much earlier but valid will. If a probate claim is going to be brought, it is often the case that potential claimants in such cases say to the solicitor who they allege has been negligent, please will you indemnify us against the probate claim. It is rare, in my experience, for the insurers of a potentially negligent will writer to offer to indemnify against the costs of making bringing a probate claim, in distinction to the sort of rectification claim, where it's not uncommon for insurers to think, actually, it might be cheaper to support financially this rectification claim than let the problem go unsolved. So in the probate claim, it's rarely the case that the insurers of the negligent will writer will offer the indemnity. The beneficiary in these circumstances will need advice from somebody else who isn't you, and the drafter of the will in question is very well advised to adopt a position of scrupulous neutrality, even if they are a personal representative and are a necessary party to the claim, and to provide all assistance and information that they are able to enable the probate claim to be fought out fairly as between those who have got the argument as to the beneficial interests in the estate. In the first instance, obviously, any Lark and Nugas request that is made of the will drafter should be answered in full, and any further requests for information and assistance should be responded to in full, taking care as appropriate not to provide documentation or information that might be confidential to anybody else. And that might happen in the case where husband and wife have made a will, and there's some information on the file that's confidential to one rather than the other. So care needs to be taken there. But basically, give all the assistance you can, but you may find that your will is eventually defeated in a probate claim, and there's then possibly a problem for you down the line. So what, Marcus, is the position after the probate claim has been fought out to a conclusion and your will is found not to be valid?
Well, we all know that the costs of a probate action can be really quite significant. And if the reason there had to be an action in the first place comes down to your failure, then you may end up paying all or at least a large proportion of those costs. There's the possibility of a secondary negligence action after the probate action is concluded, but it's also worth remembering that if you or the firm are parties to the probate claim, then even if you were properly neutral in conducting the claim itself, then the costs may be dealt with there and ordered against you in the claim. And I'm also aware of at least one case where a solicitor who was said to be negligent was added to the claim afterwards for the purposes of a third party costs order under Section 51 of the Senior Courts Act. You get added to the claim and then you have an opportunity to say why you shouldn't bear the costs. If it's a freestanding action, the claims will be because either the claiming party has irrecoverable costs, or the estate itself has borne the costs, which has had an impact on what that party gets out of the estate. This can lead to quite difficult questions of quantum, because what the claimant has actually lost may not be the same as the costs ordered. So other than the costs risk, a disappointed beneficiary may have a claim. We all know typically you have a complementary duty to the beneficiaries and the intended beneficiaries of this will. So if a will under which they would have benefited is invalid because of some defect for which you're responsible, and also if a new will including them is never drawn up at all, which is what happened in White and Jones itself, then you may very well be liable for a sum equal to what they would have received net had you carried out your duties properly. More remotely, in my view, it's not entirely beyond the bounds of possibility that there can be loss flowing from the delay caused by a probate case. Perhaps some liability incurred or opportunity lost by the estate while the 2 years of a probate claim went by. Now, remoteness of damage is likely to be very much an issue in that kind of case, but I think it's certainly possible that there could be reasonably foreseeable loss of that kind. So there's a complaint against you for negligence, a freestanding negligence claim, let's say, and in all professional negligence claims, limitation is almost always in play. So what can you say about a limitation position, Kath?
It depends in the first place on the sort of loss and the sort of claim that is being brought. There can be the lost inheritance, the beneficiary's claim for the benefit they didn't get. As Marcus has said, the irrecoverable costs of litigation, which would typically be a claim by the estate for the reconstitution of residue by those lost costs. But identifying what the loss is and whose claim it is important before looking to limitation. If the claim is a White and Jones type disappointed beneficiary claim, the primary limitation period in tort is the usual 6 years, but it's 6 years from the cause of action being complete. That is when the loss is suffered. And the case of Bacon and Howard Kennedy it says that in the case of a negligently executed will, that the loss occurs and the cause of action is complete only at the date of the testator's death, when nothing further can be done to remedy the problem. As Marcus has said, if the problem is that no will was ever executed, then the time will run from the time when instructions were given. There may be some doubt about when the instructions are sufficiently complete to say that the duty to draft the will started, but essentially it's when the instructions are fully given. So that's a 6-year period. In some cases where the estate has the cause of action by stepping into the testator's shoes, there may be a contractual claim, but it's unlikely that the usual 6 years for a contractual claim will ever give a longer period than the 6 years in tort. If it is a claim in tort, there is in all cases a 15-year long stop given by the Limitation Act from at latest the date of execution. That is when, as it were, the negligence was completely done, or the negligence was completed. So if the will was dated more than 15 years ago, you probably got a problem, unless, I'm sorry, you will have a problem. The only other wrinkle in the limitation question is where it looks as though the 6 years may have gone, but the claimant didn't have the knowledge of the negligence until more recently, and they may then have the 3-year period given by the Limitation Act as amended by the Latent Damage Act, because they didn't have knowledge of the problem. But that is subject to, as I say, the 15-year long stop. But there have been a number of cases where there have been more discussion about limitation. And I know that Marcus has views that he would like to comment about at this stage on those other more complex limitation points.
I have a bugbear with what I consider the terrible decision of the Court of Appeal in the case of Daniels and Thompson. What happened in that case was that a solicitor advising on estate planning failed to ensure that an interest in possession was brought to an end. In due course, the testator's executor, who was also sole beneficiary, but crucially he brought the claim as executor, sued for breach of the duty to the testator. And the claim failed because what the Court of Appeal said is, well, if you're right that the loss was suffered by the testator, it was suffered when the wrong advice was given, so it was well out of time. Now, I think that's wrong. I think the loss was contingent when the advice was given, and it was only suffered at death when the tax became due, or 7 years before then when some tax was going to become due. But in fact, the Court of Appeal goes on, well, the testator didn't suffer any loss. She didn't pay any tax. The executor was liable for the tax, and that was different somehow. And in any case, the executor was entitled to indemnify himself from the estate, so he suffered no loss, which frankly bewilders me. There was no claim brought on grounds of a duty to him as residuary beneficiary. And there are a couple of cases which at least suggest that may be a way out of this problem. In Rind and Theodore Goddard, the claim for defective tax advice was brought on the basis of a duty to the residuary beneficiary and on the argument that the loss was suffered at death. An attempt by the firm to strike it out on the basis of Daniels and Thompson failed. but the matter thereafter settled, and the law here remains in a highly unsatisfactory state. So in light of that, should you ever have a case like this, or indeed in any of the other areas we've covered, we do urge you to seek counsel's advice, preferably from Radcliffe Chambers. That, I think, brings the main substance of what we were going to cover to an end. We've just got a couple of questions. Someone asked, I mentioned section 48 protection, that is seeking the approval to rely on the advice of counsel of 10 years qualification. The Act is the Administration of Justice Act, and I think it is the 1985 Act, but I sometimes do have a tendency to have to check whether something's 1985 or 1982. So that is my answer to that one.
And now that Marcus has mentioned both those years, which the two I had in mind, I'm not going to offer a definitive opinion, but we can put a note on our case list about that to be absolutely sure, not get it wrong. There's another question about the area I was talking about previous wills being marked. The question is, should previous wills be marked as revoked on the original will itself or on a separate note? It's my view, there is no, I don't believe there's any authority on this particular point, but it's my view that it would be the best thing to do is mark it on the original will itself. If someone's hunting for the original will, finds the original will but doesn't find the separate note, you've got the problem that you were trying to avoid by the marking not being on the will. I'd mark the original will. Obviously, clearly, with the date of the marking and so on, you might want to have an attendance note saying, and then I mark the original will as revoked, and have that on the file as well. Hopefully, the information then will be apparent when somebody comes to look into the will storage system for the wills and can see the sequence of events that has happened. I'm just reading the last question in the Q&A. It said the firm are the executors of a will where there could be a claim against the estate. Are there any circumstances in which a copy of the will can be sent to the potential claimant, or should the potential claimant be told to seek independent legal advice with view to executors receiving a Larkin Nugas request? If the will appoints your firm as executors, I think it would be, and you therefore are the, as it were, have title to the will, and a potential claimant comes along, I think it would be appropriate to send that to the potential claimant when they make their Larkin Nugas request, not just as a I want to cause trouble. Let a formal request be made to your firm for that, and then you will be under the Larkin Nugas duty to answer, and subject to any confidentiality questions. That's my view of that.
I would agree with that. I'm just going to pick up a couple of quick and easy ones. Can a will draft a charge for responding to a Larkin Nugas request? No, they can only seek their reasonable costs and expenses of copying and sending it out and so on, but you cannot claim a fee for it, in my view.
There's a question on limitation. Should clients be revisiting their wills every 15 years at least then? Does that happen in practice? If the client is concerned that they should always have a claim over against the solicitor who they think has drafted, or that they think their solicitor has always drafted their will negligently, then in a sense, yes, you might advise them to review their will every 15 years. But actually, in my view, the appropriate advice to a client is you should review your will every probably 5 years, or on the happening of important life events such as the birth of children, marriage, death of parents, children, and so on, and that it's the sign-off letter probably wants to say here's your will, or here's the copy of your will, we're storing your original safely, but do remember that things will change in your life and you may want to review every 5 years, if not at the happening of significant life events. There's another question. When taking instructions for a will, can you exclude liability to beneficiaries? I think that's certainly an interesting question. I don't know offhand the answer, but my immediate thought is you'd have to make that contractual arrangement with the testator, and it would be an unwise testator who would say, yes, please draft my will and I'll pay you for the job. But yes, I'm going to sign up to a contractual situation where if you get it wrong, nobody's got a remedy against you. I'd be interested to see somebody try.
I would too, and I think a court is going to lean very hard against any such attempt. Quick one, should non-executor will writers still respond to Larkin-Nugas requests if they refuse, saying they're not the executor? The duty to respond to a Larkin-Nugas request is your duty as the will drafter. It is not necessarily connected to being an executor. So yes, they should. I'm trying to think my way through the answer to a much more complicated one, which I've now lost. Can a testator's intentions in respect of an asset during their lifetime override any prior express instructions as to its disposal on their death? Testator instructs solicitor to bequeath land to someone. Solicitor fails to do so. Shortly after those instructions, testator instructs solicitor to assist in the sale of the land, but gives no indication of their intention to leave it to exchange. Before the land can be sold, the testator passes away. Can the intention of the testator in life override their express instructions for disposal on death? I think the way I would frame that is the solicitor, when the disappointed ex says you were supposed to draft a will leaving that to me, say, well, yes, I didn't, but those instructions were implicitly revoked before death because the testator told me to sell it. So I think, yes, that's the way that would work.
That sounds right. Although I haven't seen the written question. I'm following slowly. I'm trying to pick up on another one, a comment from someone who obviously practices in the professional negligence area, that if you're not storing the will, it would be a good idea to have a file note to that effect. The observation is made that the writer has seen several claims where the assertion that the defendant solicitor ought to have the will in safe custody couldn't be rebutted because there was no file note to that effect. I completely agree. If the testator says, no, I want it, I want the original, I don't want you to hold it, I'm going to look after it, you want to keep the testator's letter to that effect and make a note of that fact on the file. You picked up any more that you could?
Someone asked, in the absence of disclaiming tax advice, one could be liable, and someone asks, equally, could a solicitor be negligent for not addressing other aspects of estate preservation in terms of care fees? In principle, I suppose, yes, if you don't have some thought to care fees, then that may be a problem. However, I am also of the view that most care fee avoidance strategies are ill-advised. So I have my doubts that there ever would be a claim for failing to avoid care fees. I think it's unlikely that there would be a substantial claim of that kind.
I think there would have to be very specific instructions to the person asked to give that advice as to what it was that the testator, or I think it wouldn't really be a testator problem, it would be the strategy of saving care fees by some route would require a specific retainer in relation to that aspect, and it probably is sensibly hived off from the retainer to draft the will, because I think it's a much broader question. There's another question. We're often asked to destroy previous wills. Should we do so? Well, my view is that previous wills should not be destroyed, because there is not infrequently a need to go back down the chain of revoked wills to see which is the last valid will, because a later will turns out not to be valid for whatever reason, and it's more convenient to have in my view, the will that I've suggested, the previous will that I've suggested you mark revoked by the will dated the 23rd of September 2021, actually still on the file, so one can say, well, now the probate action has determined that the will of 25th of December 2021, made after Christmas lunch, was invalid because nobody knew what they were doing anymore. It's much easier if you've got the previous will from today on your file, although marked revoked by that later will, and then the court could say, well, can't admit the later will to probate because it's invalid, but look, we have got the actual physical document that can be admitted to probate. Of course, it's marked revoked by, but the order of the court has said that will was not valid, so it's not revoked at all, in fact. But you've got the physical evidence. That's my view. I think that probably takes us to a close, so Marcus.
Yes, I think it's probably a point to draw a line. Thank you all for attending and listening to us this morning, and we hope to see you in person at some point over the next year or so, if those meetings ever do in fact come back to us. So good afternoon, everyone.
Thank you, everyone.